God save the state of Texas and this honorable court.
Be seated, please. Welcome, everyone. We want to start off again by thanking the University of Texas Law School for being one of our several homes away from home, since we don't have a home courtroom, and this is a great place, and we appreciate, I hope you all found parking here. It's not easy to do, but we sure appreciate the law school hosting us for this, and any students that might have the time to come, we appreciate. All right, let's proceed first to our the first case. We only have two cases on the docket, 20 minutes per side. Let me know if you've reserved. I assume you're reserving a few minutes for rebuttal, but let me know as I call the case. The first one is 1524-0089, Texas Department of Public Safety versus Leroy Torres. Is Appellant present?
Yes, Your Honor.
And for Appellee?
We're, Your Honor.
All right, reserving any time for rebuttal, or?
Yes, Your Honor, reserving 5 minutes.
All right, you may proceed.
Thank you. Jason Contreras on behalf of Appellant, Texas Department of Public Safety. May it please the court. It is undisputed that when Trooper Leroy Torres returned from military service, he was reemployed by DPS to the same full-duty trooper position he previously held. Therefore, Section 4313 of USERRA, the reemployment section of USERRA, does not apply, and Torres cannot challenge events that occurred post-reemployment under Section 4313. This case went to the jury on the wrong theory of liability under USERRA. An affirmative defense question was omitted to which DPS was entitled. Further, the evidence shows that Torres's voluntary resignation caused the breakdown in the interactive process with respect to his accommodation request. He was awarded damages based upon the wrong position, and finally, Trooper Torres failed to prove up his attorney's fees to the jury as required under the Texas Rules of Civil Procedure.
Let me take a couple of those, breaking those down just for a second. So what should he have brought? What kind of claim should he have brought? Not that your duties to him is to inform what he can sue you for, but.
Trooper Torres' post-reemployment was protected by USERRA Section 4311. 4313 is the section that protects a military member up to the instant of reemployment. Once that reemployment is triggered, and as he continued resuming his employment in the position, full-duty trooper once again, that's when the protections under 4311 kick in, once again after reemployment occurs. And as Trooper Torres admits in his briefing to this court, DPS complied with USERRA's reemployment requirement under Section 4313. He was promptly reemployed in the same trooper position he would have been employed if not interrupted by military service, in strict compliance with 4313. And significantly, and this is an important part here of the analysis, is that when the reemployment occurred in or around February 2009, DPS at that time had no knowledge or notice that Trooper Torres had acquired an illness during his military service.
What do we do with I'm sorry, I've lost my voice a little bit. What do we do with the federal regulations that he cites suggesting that maybe 4313 could apply after reemployment if the employer doesn't discover the disability until after the employee resumes work?
They are misrepresenting that code of federal regulation, and there is no case in any circuit that has held that that is controlling authority to interpret this case or to fashion that into the protections under 4313 case. And that's the bottom line on that.
But how are they misrepresenting it?
Well, because That's simply their legal argument, but there's no legal authority that adopts that Code of Federal Regulations. I believe it's 1002.226. Your Honor, I believe that's the one you were asking about. There is no authority that analyzes or interprets that to mean that post-employment re-triggers protections under Section 4313. And that's the position that they're making, but the bottom line is that there are no cases in support of that. That section addresses, yes, the obligation of the employer to find a reasonable combination, but even in the language of that Code of Federal Regulation and issue, it doesn't say what Torres' attorneys are representing it to mean. And the bottom line here, there are no cases that hold that section 226 does not, that Code of Federal Regulation does not convert a section 4311 disability accommodation claim into a section 4313 reemployment claim. Instead, the regulation merely states that the employer must make reasonable efforts to help an employee become qualified to perform the duties of the position.
So, of course, there's no Texas cases, period, on any of these statutes, right?
That is correct, but we do have from other
And
jurisdictions.
we do, and Fourth Circuit's a great circuit, and Virginia Supreme Court, wonderful Supreme Court, but not binding on us. And of course, we're bound, we need to interpret the statute, not Fourth Circuit cases, right? So I'm looking at 4311. What part of that says he can bring a claim? I mean, my understanding is their claim is they needed to make an accommodation to him. But 4311 prohibits discrimination. It doesn't say anything about an affirmative duty to accommodate. So, in fact, the statute doesn't, once you're reemployed, the statute doesn't protect service members if the symptoms of a disability appear after reemployment anywhere, does it?
Well, I believe that Trooper Torres is protected under 4311 to make a request for reasonable accommodation during his employment, even if the illness that is connected to his military service did not manifest until after his reemployment. And
So
that's,
I'm worrying, I can't find that in 4311. It says he shall not be denied initial employment, reemployment, retention in employment, promotion, or any benefit of employment. I mean, accommodation would be a benefit of employment normally only if the ADA applies.
that is correct, Your Honor, but we do have at least one published federal circuit, the Fourth Circuit, that specifically states that in the situation as we have here, it was very, very much on point here, is that 4313 is not re-triggered based upon a latent illness that doesn't manifest itself until after reemployment. And I apologize, I did find one other interesting federal district court case that further supports our position. And I would note that in Appellee's brief, they didn't cite to one case that holds for the proposition that Section 4313 is re-triggered under these facts. If I may?
Or you can just tell us, I got my Westlaw pulled up.
The site is 2015 Westlaw 13655-672. That's out of the Federal District Court of Arizona. And it was a similar situation where the Arizona Federal Court declined to hold that Section 4313 claim can be invoked to protect reemployed employees, and here's the interesting language, from post-reemployment adverse actions. In that case, it was a termination action. So it even says, even with the adverse employment action such as termination, 4313 doesn't get re-triggered. This was a situation in which a veteran who was fired for an altercation occurring several months after his reemployment, once again, occurred after his reemployment, unsuccessfully argued that Section 4313 was triggered by reemergence at such time of his post-traumatic stress disorder that had been detected and gone into remission before he sought reemployment. So it's just, I think it's another nail in the coffin on that argument, because we do at least have some persuasive authority. Of course, it's not controlling authority, but we do have persuasive authority from other circuits, from other states, that support DPS's position that under these facts, 4313 doesn't get re-triggered because he had been reemployed.
Are you aware, excuse me, are you aware of any case law that addresses the Department of Labor's commentary?
I am not, Your Honor. I believe this court may give that Department of Labor rules and regulations Skidmore deference, but it's certainly not controlling, and it's not dispositive here. And I would note that those regulations were from 2005. And if that was the controlling law that all the courts of the land are going to follow, well, the Fourth Circuit had a different opinion 11 years later in their opinion in the Butts case. So did the Virginia Supreme Court in the Huff versus Winston case, which holds similarly that you don't get to re-trigger 4313 after reemployment. And I think that's the defect of Torres's argument here. And if you look at their brief on appeal, his attorneys are citing to one of their lawyers talking during the jury conference. That's not legal authority. That's legal argument, which has no basis. They're explaining their position, citing to the Code of Federal Regulations, but they have not one single case that supports their view.
Yeah, I'm just trying to figure out, you know, we've got to write an opinion on no matter what we do, and if you're asking us to reverse the decision in favor of Trooper Torres, and so we've got this commentary out there that no court has addressed from the Department of Labor that seems to favor him, and then we have case law out there that seems to favor your side. So how exactly do we reconcile that? Because there's no sign in any of those cases that anyone ever raised that commentary to those courts. And if no one ever raises it to you as a court, you're probably not going to discuss it, and you may not find it. So how do we reconcile those?
I mean, I think really what we have here is a case of, yes, you have some rules and regulations that were, that came down in 2005. And then we have established case law, published Federal Circuit Court of Appeals case law addressing this exact issue that didn't mention anything about that, about the Department of Labor rules and regulations. They're relying upon that, but I think that this court has the discretion to disregard that and rely on the established, at least persuasive authority that we have on existence, of course not out of any Texas Court of Appeals, but at least from those other jurisdictions, it's certainly persuasive.
So you've looked for, you know, usually these regulations, you got to post them, notice and comment, you take the comments, you respond to the comments. Did nobody comment about, I mean, it is a preamble. It's not exactly the regulation, it's the preamble, but did anybody comment, you know, statute doesn't say anything about restarting the clock on the statute here. Was there anything like that, or is it too old to find it?
I think one can opine that, yes, it is too old. If it was, once again, if it was controlling law, it would have been raised in these other circuits as somehow controlling, you know, on the issue here. But once again, we have cases 10, 11 years later that are supporting DPS position on the case.
Could I ask you about attorney's fees before we get too far to the end of your time? You argued that the reasonableness of attorney's fees is a question of fact to be determined by the jury. But you say here is federal law. Do the Texas attorney fees standards still apply?
It absolutely does, and there is at least one U.S. Supreme Court case directly on point. It's, I believe, in our reply brief, Felder versus Casey, U.S. Supreme Court, 1988, and that holding specifically says that states may establish the rules of procedure governing litigation in their own courts, where state courts entertain a federally created cause of action.
So that's the procedural versus substantive distinction.
Yes, and the other important part to mention is that Torres didn't file his lawsuit in federal court. They chose their forum, they chose the venue, they chose to file and litigate and try this case in front of a
How
court
long
in
did
Texas.
how long did the jury trial last? I mean, I stand to be corrected, my colleagues, in the year and a half almost this court's been in existence. I think this is our first case where we actually got a jury verdict. I'm so tired of ultra vires and pleas to the jurisdiction and interlocutory appeals. We never get jury verdicts. This is exciting. So
kind
how
of a
long was the
refreshing
jury
change.
trial? If it goes back to jury trial, how long is it going to take to do it again?
Oh, I believe it was about a 4 or 5 day jury trial. The jury came out pretty quickly on it, but it was basically Monday through Friday. And the case was tried on the merits. Sovereign immunity had already been established. The state can't argue that, but we can certainly argue the merits here of the case. And just once again, to go to attorney's fees, the case law is overwhelming that attorney's fees must be proved up before the trier of fact, and that's the jury. There was no agreement of a bifurcated trial, certainly. There was no request in which Torres, through his attorneys, attempted to invoke Federal Rules of Procedure 45, subsection D. They just did, this is just how they did it. So they're kind of coming up with that after the fact on that argument. And that's, I think, a pretty established issue on attorney's fees. And so therefore, they waived their attorney's fees. Those were waived because they didn't follow the proper procedure under Texas law.
Thank you, Mr. Contreras. I believe your time's up.
Thank you. We would simply request that the case be reversed and rendered based upon the fact that Torres abandoned their Section 4311 claim, or in the alternative, that the case be remanded back to the trial court for trial on a Section 4311 claim, which is what this case is really about.
Thank you. So, Mr. Lawler?
Mr. Chief Justice, and may it please the court. My name is Brian Lawler. I am here with the distinct honor and privilege of representing Captain Leroy Torres, who is seated right behind me. This is an important groundbreaking case, as Justice Field pointed out. It's also a case of first impression. Right? There isn't another case like this out there. And as the court is aware and has already said, this is the first time a USERRA case has ever been brought in or tried to verdict in the state of Texas. Contrary to my colleague's position, we chose to file in Texas State Court. We had to file in Texas State Court. And they would do well to remember they fought that decision. The Supreme Court of the United States said that's where it belongs. That jury verdict was correct. The trial court did not commit any reversible error in its jury instructions, which we argued for 4 hours. The award of damages is correct based on the position that Captain Torres would have held, but for his military service and subsequent illness. And the award of attorney's fees, the law is not what DPS thinks it is. It is actually controlled by the Fifth Circuit. Not binding here, I understand, but the Mathis decision is where we look to which court and which law governs the award of attorney's fees. As I've said before, this is a case of first impression. So to Justice Field's comment, there is no case law interpreting the DOL regulation. And to be clear, 1002.226 is the Code of Federal Regulations. But what we've been talking about, the 20-year-old rule, well, it may be 20 years old. There isn't a newer one. And so to, again, I think it was Justice Field, your point, maybe yours, Mr. Chief Justice, it is a preamble. So when the Department of Labor, which was charged by Congress in Section 4331 to promulgate USERRA, basically write the plain language interpretation of USERRA, the Department of Labor did that. And in so doing, it sought comment from practitioners, legal authorities, law schools, professors, academics, on the implementation of the statute as codified by the regulations, which then became the final rules. That sort of an arcane site, right, the 70 Federal Register site, was not addressed in Butts, was not addressed in Huff. I agree with the court. I don't think it was raised. I've not seen anything in not only the opinions, but the briefings in those cases where that was raised. So again, not only are we a matter of first impression in this court, because it's the first Texas state USERRA case, I think it's a matter of first impression for how does a court interpret that rule? And as Your Honor pointed out, it's not the court's position to interpret what the Fourth Circuit said or what the Virginia Supreme Court said, but the statutes at play here. This case is a 4313 case, and that Department of Labor regulation and the comment on it, I think, speak volumes to why it is.
What type of deference do we owe, assuming it applies, what type of deference do we owe the department's interpretation of the statute itself?
Well, it's obviously not Chevron any longer. Kaiser would apply. Loper Bright would apply. And I think Loper Bright applies because one of the tests, and I don't have them all, and I apologize for that, but one of the Loper Bright tests is if the agency was assigned the implementation of that regulation. Excuse me. In this case, the Department of Labor was assigned by Congress in the statute, Section 4331. Department of Labor promulgate this statute. So I think it's Loper Bright, which obviously superseded Chevron, and I think to that extent, although it did supersede Chevron, we still have a carve-out where there is deference to be given, and I think in this case it's clear when the Department of Labor was told, implement those regs, we can now give it Loper Bright.
So I may be missing it, but it appears to me in all the possibly relevant parts of the federal statute, there's only one mention of disability, and that's 4313, and it appears to be more favorable than the Americans with Disabilities Act, because it says if you have a disability incurred in your service, uniformed service, and you're not qualified to take your position or what your position was or should have been if you remain, you're entitled to be hired at the same pay, same status, same seniority, and closest equivalent we can find. Now, compare that to the ADA. If you're not qualified, you're not qualified. If because of disability you can't do it, you're not qualified and you're out of luck. So that is obviously much more favorable if you can get under 4313, but the problem is does it apply to people when every other court, I mean, do you disagree that every other court's interpreted 4313 says it ends the second you're rehired at your old position, which your client was? He was rehired, it was just subsequent, it turned out he was not qualified.
I don't disagree that that's what those courts have written.
Yeah.
I disagree that those are, first of all, holdings. I think that's dicta. I think it's one court restating that sort of easy dicta, and that is 4312 and 13 apply to the date of reemployment, 4311 applies after. There's no, first of all, Petty, Francis, Hart, Clegg, and Pittman that the state cites, none of those are a reasonable accommodation case, so they're easily distinguishable on those grounds. Two of those folks were terminated for cause and then subsequently sued under 4311. So the dicta is simply 4311 after reemployment, 12 and 13 up to reemployment. So I think those are easily distinguishable. And again, there isn't a court that's addressed this, excuse me, reasonable accommodation issue. Now, well, the Fourth Circuit did, and the Virginia Supreme Court did. In Butts, which was the Fourth Circuit case, Mr. Butts was, first of all, the disability was only discovered years after he was terminated, and oh, by the way, he was terminated for cause. And then Ms. Huff, one of her disabilities was manifested. Right? She came back from Afghanistan pretty banged up, and was reemployed as a bailiff, as a deputy sheriff, and then had the heart attack. And her physician said, well, that's also service-connected. And so, but that's not the case here. Captain Torres did not have a single manifestation of his illness until some 17 months after he'd been on the job. And both Captain Torres and the department recognized he was not going to be able to perform those duties of a frontline state
Right.
trooper. So, so that's, I don't know if I answered Your Honor's question.
No, it's just, just appears to be a hole. And question is whether a court should fill the hole or Congress ought to fill the hole. Does appear to be a hole. You can't get in under the ADA because you don't have to make accommodation unless, except in the service-related statute, but it has to be as of the time you were hired. It can't be something that shows up later. And I assume from these cases and just what you read in the papers, there's a lot of folks that come back, they're happy to be back, and then things start happening, and it's turns out you didn't come back exactly the same person as it was when you left for deployment.
Well, and I think to further Your Honor's point, that there are obvious injuries of war when people come back missing, limbs and parts,
Right.
or don't come back. But there are tens of thousands of service members who have come back in the 20-odd years with latent injuries, like Captain Torres. And I think it's reasonable. First of all, I think the policy argument alone supports this court interpreting the Department of Labor reg and 4313 A3 specifically in USERRA to support what will inevitably be more, right? It's not just Captain Torres. We're going to see more of these situations. And I mean, if his condition had not materialized until last year, what then? And so my point to that is, it's going to keep happening. So is it worth the wait and the X chance possibility that Congress does this?
Since
Or-
things are working so smoothly in Congress.
Exactly. Or is it this court's opportunity, again, as a matter of first impression, certainly in the state of Texas, and again, I'm not aware, as Justice Field pointed out, any other court that has interpreted that Department of Labor final regulation, it is this court's opportunity to do so. We would invite that. I think that the manner in which that was presented to the trial court and that the jury instructions were granted, I don't think that's reversible error. I mean, I think one could actually infer the trial court did interpret that regulation and say, yeah, this makes sense, that when the disability is only noticed after prompt reemployment, and no one disputes that Captain Torres wasn't promptly, timely reemployed to the correct position, he just couldn't do that one anymore. So to further my policy hypothetical, does that mean once the situation is fully manifested, they're out of a job? That can't be the right answer, and we've not talked about it yet, but the pro-veteran canon suggests that can't be the answer, right? So USERRA is what was enacted in 1994. It's the third in a progeny of pro-veteran support statutes. The Selective Training and Service Act, 1940, became the VRRA in 1974, and now we have USERRA. Congress intended that it be broadly, liberally construed, starting with the STSA. We have Boone versus Leitner, which is a 1943 case that says the same thing about the STSA, and every subsequent iteration of the statute, Congress has reaffirmed that, and the Supreme Court has done so as recently as 2021. Circuit courts are doing it every day.
Could I ask a question about the communications in this case? There's a dispute about who dropped the ball in communicating, and is that a finding that we have to defer to the jury, or how does that work when we're examining whether whose fault it was that the transfer was never completely accomplished?
I think that is a question that should not be disturbed because of a factual determination that the unanimous jury
Right.
took them an hour and a half to come back 6-0. They held clearly that when the December, I think 16th, 2011 memo left, or email, internal email left the Human Resources Department, the last thing that was written by anyone at DPS, was everything is on hold until we figure out what's going on or some.
So why did your client resigned, right?
He resigned in August of 2012.
And he resigned, now my understanding, he was put on unpaid leave, is that why he resigned?
That's correct. He had exhausted paid leave, DPS has actually a rather nice feature where they can exchange paid leave. I don't know how that works. It'd be great, but they can, I guess, some troopers or DPS employees, maybe it's all state employees, I don't know, can exchange paid leave if you're out and some other people have more. I don't know the answer to that question. I know these were all presented to the jury. The evidence was all presented to the jury, and the jury found pretty clearly that the breakdown was on the state's part. And I think to that end, if we look at, and I think it's page 19 in our brief, Major Palmer, who was designated as the state's representative, he was speaking on behalf of DPS. He admits clearly that there's no further communication, not only between DPS and Captain Torres, but intra-DPS. Nobody said anything. So in December of 2011 through August of 2012, no one said anything. And to your point, Mr. Chief Justice, the ADA requires more of a two-way interaction for the, for the process, the interactive process. USERRA doesn't. USERRA is a much better statute, quite candidly, for disability accommodation. It puts the onus on the employer. And here we have 9 months of zero employer action of any kind to determine what, if anything, to do with Captain Torres. What they had an obligation to do and needed to do lawfully was find him a equivalent position of like pay, seniority, and benefits. That could have been anywhere in DPS. The state of Texas is the employer. It could have been anywhere in the state of Texas. But they admitted not only didn't they look within DPS, they didn't look within the state. Just because Captain Torres said, I'll go do this non-commissioned position for less money, doesn't make that right. He could have said, I'll go shovel fries for $12 an hour. It's not about what he wanted to do to make things easy. It's about what he is lawfully entitled to. And what he's lawfully entitled to, and those are the damages that we put up, was a position of like seniority with all the seniority-based pay increases, with all the annual or semi-annual Texas state employee pay raises. And that's what we painstakingly put on before the jury for about an hour of whiteboard, and dry erase marker, but they got it, and they awarded him every penny as they bought it. And further to that point, there's not a scintilla of evidence of what the lower pay rate should be. Texas just keeps saying it shouldn't be that number. Well, they never put on what number it should be either. Did I answer your question, Your Honor? Yes. If there's nothing further, Your Honor, I'll...
Thank you, Mr. Lawler.
Thank you.
Mr. Contreras, 5 minutes.
Thank you. In reference to the evidence that was presented at trial, and in particular the HR email, I believe in November of 2011, on the tail end of that year, the HR email was addressing placement of Trooper Torres into that position, but they had certain work-related issues that they had to figure out, because the non-commissioned driver's license examiner position that he specifically requested to be transferred into involved things like going out on road tests with candidates that are applying for their driver's license. And there was an issue whether he could only perform sedentary work in the office, or if he could go out in the field and do the driver test, basically. So, and if you look at the email that's addressed, they're trying to figure out how that would square with his salary. They were engaged in the process. But what happened the following year was that Mr. Torres unfortunately had further health issues and went on leave, okay? And DPS never terminated him. They never disciplined him. They never said, you've exhausted your leave, you're fired, which employers can legally do. They never did that. The evidence presented to the trial, to the jury at trial, was that his position was there for him, waiting whenever he sought to come back. And that was essentially what hampered the process of final placement, is because in that final year he was there all the way through the time in which he resigned in August 2012, he was on literally extended leave that whole time. So to impose a burden on DPS to offer him a job position when he's not there in the workplace. You can't engage with him in the interactive process because he's not even there. But DPS never faulted him for that or sought to terminate his employment.
So was it not possible to have email communications with him during this period that he was out, or he wasn't reachable at all?
I believe there was some communication with the supervisors. I believe he had some text message communications with a couple supervisors. But the other evidence, and I think is also important, is that DPS, in the evidence presented, specifically stated to keep Mr. Torres, Trooper Torres, on modified job duty, which he had been placed on, until the transfer was effectuated. And they didn't put a deadline on that. They didn't say, okay, he has 6 months, he needs to come back in 2 weeks, or else we're going to fire him. They never did that. That was the evidence that showed that the bottom line is that his job was there the whole time, and DPS didn't pull something and say, oh yeah, here's our regions. Oh, you know what, Mr. Torres, we have a position open up for you over here in the Panhandle in Lubbock. You need to move over there. No, the position was available for him in Corpus Christi, Texas, in the driver's license office there, where he could have come to work at any time.
Could you clarify on your sufficiency of the evidence arguments? Are you claiming legal sufficiency or factual sufficiency, or both?
I would claim both because based upon that evidence that was presented, we get the affirmative defense, and that's really what the case is about. And on the Murray versus Mayo Clinic case that I gave you the cite on, that was kind of interesting, and specifically in this regard, because the federal district court dismissed the 4313 reemployment claim, proceeded on the 4311 claim, and that case went to trial on the 4311 claim, and guess what? That employer won on the affirmative defense, that the employer established that it would have taken the same action without regard to military service. And because it's a 4311 case, DPS was improperly denied that affirmative defense question in the jury charge. And I guess just kind of big picture here in mind, and looking at the statute and looking at the unique statutory scheme of USERRA, it's very different from many of the other civil rights statutes. And with regard to reemployment, it provides nearly strict liability for the failure to reemploy a military person after an absence, meaning it's much easier to win on a Section 4313 claim versus a 4311 claim where you get an affirmative defense. And so that's why Torres is so steadfast in their position in arguing that this is a 4313 case, because it's easier for them to prove. The standard is so much easier because that's the way the statute is written. But the bottom line is they don't dispute that he was reemployed, and under at least the persuasive legal authority on the other cases that we can cite, support DPS's position that 4313 doesn't get re-triggered in the situation in which you have a latent illness that manifests itself after reemployment.
So your time's up. You got 25 words or less to finish it.
Yes. So that's really what's going on here. Is the bottom line is that's why they're trying so hard to repackage this case as a 4313
We got
case.
that.
Thank you very much. We would respectfully request that the
Thank you.
case be reversed and rendered. Thank you.
We'll take a brief adjournment, 10 minutes, and then we'll take the second case. Thank you, counsel.
All rise.